Good evening and welcome to part 2 of SAMVAD's 4-part public series on child forensics in child sexual abuse cases. For those of us joining for the first time, SAMVAD stands for Support, Advocacy, and Mental Health Interventions for Children in Vulnerable Circumstances and Distress. We are a national initiative and integrated resource on child protection, mental health, and psychosocial care, located in the Department of Child and Adolescent Psychiatry at the National Institute of Mental Health and Neurosciences, Bangalore. This particular public series has been developed by SAMVAD as a part of a range of different initiatives being conducted to mark 10 years of POCSO, critical reflections and ways forward. 10 years of POCSO also means that it is time to take stock of the progress made under the POCSO Act and identify the challenges that require our attention. This series, therefore, has been developed to generate engagement and discussion on some of the challenges in the implementation and in the conceptualization of the law. These imperatives, as we'll see through the course of this series, relate to the issues of the credibility of child victim witnesses, interviewing and eliciting evidence from children, appreciation of oral and forensic medical evidence, among other considerations. Before I hand over the session to our moderator, Dr. Shekhar Seshadri, a few words of introduction. As most of us in the domain of child rights in India are aware, Dr. Seshadri has worked for over 40 years in the areas of community child mental health, with children in conflict with the law, and of course, with child victims and witnesses in cases of sexual abuse. Dr. Seshadri's work has also held particular importance for all of us who've come after him, most specifically because it has marked an introduction of transdisciplinary approaches to issues of child victims and witnesses in the context of sexual abuse cases. Dr. Seshadri himself has been an expert witness in over 50 to 60 cases, trying to see how best we can assist these children in navigating some of the challenges of what is typically an adversarial and sometimes hostile courtroom environment. So with that, I'd now like to request Dr. Seshadri to begin with the session, sir.
Thank you very much, Saurabh. Friends, the second part of this series will deal with suggestibility and tutoring concerns in court preparation programs for child witnesses. Through part 2, we will understand some of the issues tied to the perceived credibility of child witnesses, like suggestibility and tutoring on the one hand, and the rationale for developing court preparation programs on the other. The content of court preparation programs will be discussed to also engage with the concerns pertaining to suggestibility in court preparation interventions and how this can be avoided. Joining us today from the Child Witness Institute in South Africa are two experts in this subject, Dr. Karen Muller and Karen Holloway. The Child Witness Institute is a non-profit organization in South Africa, which has been working for over 23 years on the concerns of child witnesses in cases of abuse, violence, and victimization in cases involving children. They have undertaken extensive research on matters pertaining to children in contact with the law, reformation of justice systems, and training of stakeholders on these aspects of justice and law. They have also trained judicial officers, police personnel, and other stakeholders in the criminal justice system in several countries in Africa and Southeast Asia. A critical part of the Institute's work has included developing comprehensive court preparation programs for vulnerable child witnesses who are legally required to contend with an adversarial and often hostile courtroom environment. On behalf of the SAMVAD team, we extend a very warm welcome to both our esteemed guest speakers today, particularly Karen Muller in today's session. It is also important to take notice of the fact that no serious engagement on child witnesses can be complete without a transdisciplinary approach to the subject. Therefore, it is my distinct pleasure to extend a warm welcome to Honorable Justice Madan B. Lokur, former chairperson, Juvenile Justice Committee, and former judge, Supreme Court of India. Friends, Justice Lokur currently serves as a judge on the non-resident panel of the Supreme Court of Fiji. During his time in office in the Honorable Supreme Court of India, Justice Lokur has made significant contributions to the areas of juvenile justice and criminal justice reform for vulnerable child witnesses. In the landmark judgment of Independent Thought versus Union of India, delivered by a division bench presided by Honorable Justice Lokur, the Honorable Court read down the exception to marital rape to exclude all child wives from its purview and bring the provision in line with the mandate of the POCSO Act, which Saurav alluded to. Honorable Justice Lokur has also unfailingly contributed his time to a series of judicial deliberations organized by SAMVAD with POCSO court judges from states across the country to facilitate debate on some of the challenges faced by child witnesses in case of sexual abuse. With these words, I would now like to request Justice Madan B. Lokur to give his opening remarks. Justice Lokur.
Yeah, thank you, Shekhar. And good morning to Karen. I think it's should be early morning over there. Yeah. And,
afternoon, yeah.
Yeah, okay. And good evening to all the others. First of all, I must compliment SAMVAD for this initiative, as well as the organization in South Africa, which is with which Karen is associated, for doing this program. And I think it's extremely important, because we are now in a stage of transition, at least in India, where the rights of children have been given far more importance than they were maybe say about 10 or 15 years ago. And I think this awakening, if I may call it that, is really going to take us forward in cases pertaining to children, child sexual abuse, and even for adults in cases of sexual abuse. So really congratulations to everybody for organizing this. Well, as far as child sexual abuse is concerned, there are three things that I would like to say in the context of today's program about suggestibility and tutoring concerns and in court preparation programs. You see, one is that all of us, whether we are judges, whether we are for the prosecution or even for the investigating agency for that matter, I think all of us have to realize that children who have undergone sexual abuse are more often than not likely to suffer from some kind of physical trauma. Right? It depends upon the nature of the abuse, but certainly, there would be some kind of physical trauma that they would have encountered, and that will get reflected in the mental trauma. So physical trauma, really, one doesn't need to discuss too much about that, but mental trauma is very important. It could be some kind of a disorder that may arise. Sometimes a child who has been sexually abused may not be able to speak coherently, will not be able to think rationally. So there are all kinds of problems that a child might face. And when the child comes to the court as a witness, you see, we have to be very careful about the fact that the mental trauma is not enhanced. I remember a case which I have talked about, on several occasions, where a child, 7-year-old girl who had been, sexually abused, she came to the court 7 times for recording her statement, and on all 7 occasions, for some reason or another, the statement couldn't be recorded. Now, this is, secondary victimization, we could call it secondary victimization, but it also adds to the mental pressure that the child undergoes. So this is the second thing that we have to be very careful about, namely the mental health aspect of the child. The third is really the ambience in the court. Now, we can't have a court which, scares the child, right? It has to be friendly. The atmosphere has to be friendly. I can tell you about two instances. One is in a child custody case, nothing to do with sexual abuse, just a simple case of child custody where the judge wanted to talk to the child to find out whether the child should, whether the mother should have the custody or the father should have the custody, and so on. But when the child came to court and he saw all these lawyers, wearing black coat and, maybe white trousers or black trousers, the child was completely traumatized, and just kept running all over the court building. Now, the child wasn't a survivor, there's nothing wrong. It was a completely ordinary child, but the ambience scared him. I will give you another example of a young girl who went to, get admission in a school, a convent, and she saw these nuns in their habit, and she'd never seen, so many of them all at one place, and that she got traumatized. So really something very simple, which we don't think about can have an impact on children. So really we have to be very careful when we are dealing with children in these kind of circumstances. We need to step into the shoes of the survivor. And in India, we have, over the years, we've been trying to improve these situations so that, children, when they come, they are free from whatever baggage that they might have in terms of, trauma and all that. I don't know to what extent we have been successful. The courts have said that you can't ask questions which are very searching. There has to be a gap or a distance between the survivor and the accused. We've introduced video conferencing, one-way classes, court visits, before the testimony is to be recorded in preparation for the testimony. The child is taken to the court to be familiar with the court environment and so on, so that the child is not, suddenly placed in an atmosphere which is, very challenging in a sense. But a lot more needs to be done, and I'm glad this program is going to help us out in, understanding some of these problems. The last thing that I would like to say is that, we have been, through the court processes, through judgments, we have been looking at stereotyping children as witnesses, in the sense that there are judgments which say that a child witness is susceptible to tutoring or susceptible to suggestions. Yes, but so is an adult, right? An adult can be threatened, and well, depending upon the nature of the threat, the adult might turn hostile. So the consequence of this is that there are judgment after judgments which say that a child witness is more prone to exaggeration, is more prone to giving, giving play to imagination. Now, I'm not sure how that follows. Perhaps mental health experts can tell us about that. But the courts have said that under these circumstances, you must look at the witness testimony of a child with greater scrutiny, closer scrutiny, right? Because the child can be influenced. But that's for everybody. I mean, the court can't say that, listen, because the witness is an adult, therefore I will not examine it closely. I will believe what the adult says. But if the same thing is said by a child, I'm going to examine it, with greater scrutiny to see whether the child is speaking the truth or not. We have instances, judgments which say that a rape survivor, even if her testimony is not corroborated, there is no reason why she should be disbelieved. But that's not the standard that is applied to a child witness. That if the child says that, well, she's been raped or she's been molested or whatever, prone to exaggeration, prone to giving way to imagination, so therefore greater scrutiny. Why? So some of these, stereotyping of child witnesses, we need to have a fresh look at all this at the law. And I'm sure, as we go along in this program, we'll get some ideas, we'll get some thoughts, and hopefully, come out with a better system for children to get justice in cases where they are, victims of sexual abuse. Thank you very much.
Thank you very much, Justice Madan Lokur, for these very thought-provoking and thoughtful observations that you have made. With this, I would now like to request Karen Muller, our guest speaker, to begin her presentation. Karen, over to you.
Thank you very much. Thank you, everybody, for giving me this opportunity to address you all on this question of suggestibility. What I was very interested to hear was the word discrimination, which I think lies at the core of what we're going to be talking about and what we were talking about in the last series, where we were talking about the fact that children are viewed differently from adults. And my personal opinion, I think, is because we don't have enough knowledge of children. They scare us, and because they scare us, we're not quite sure how to interpret what they're saying, and this is where a lot of the difficulty arises. But it goes back to a point that I made before, that what we're looking at here very much is the specialization of all role players in the system, because unless you have the knowledge, it's really difficult to be able to assess the information. So today's session, we're going to look at suggestibility and its implications for court preparation. But I thought that we needed to start off by looking at suggestibility. What is suggestibility? And what does the research say about suggestibility, so that we have a balanced understanding of what this concept is before we look at court preparation. So traditionally, when we're talking about suggestibility, it has been defined, and I've given it to you on the screen. The traditional definition is the extent to which we accept or incorporate information into our memory after the event has taken place. In terms of forensics and courts, we tend to use a broader definition, and really what we're looking at is suggestibility refers to the degree to which memory at any stage of the memory, whether it's at encoding, when it's being stored, or when it's being retrieved, is influenced by outside factors, or sometimes even could be internal factors. So it's really, suggestibility is really about interfering with the memory. And that is why we need to be looking at what gives rise to that interference. What are the causes? What do we need to be careful of? Because as was mentioned, it's not just children who's suggestible. Anybody who has a memory is suggestible. So how do we know who's more suggestible? What are the danger factors? And that's the kind of information that's going to assist us in making a more scientifically based assessment. So suggestibility can result from social as well as cognitive factors. This is information that we kind of include without even realizing it into our memories. And that happens to everyone. Every time we talk about a topic with somebody else, we very often add information to that memory. So there's your infiltration. Subtle suggestions from externally, expectations, and we're going to unpack all of these where people expect you to be able to say your story in a particular way, stereotypes, leading questions, and obviously any other kinds of inducements. So if we look at suggestibility, where does it occur? Okay, now it can occur either internally, where there is no outside influence. For example, where you're thinking about something, where something has happened, and after a while you lie and you think about it, and you think about what happened, and you wonder whether maybe the person actually didn't mean this, and those thoughts become incorporated into the memory and can actually change the original memory. Then, of course, you get suggestibility that occurs externally, and that would be, for instance, where somebody suggests something to you, somebody just talks about something, and you incorporate that into your memory. So it can happen either externally or internally. It's important to remember that suggestibility is not, it doesn't occur intentionally, because if it did, that would be lying. And we're not talking about lying here. This is where your memory is changed in some way without you actually being aware that it has been changed. So there's no deliberate intent to mislead somebody. And we have to be very careful that we do not confuse suggestibility with lying. So what we're really talking about here is the contamination of the memory, contaminating the evidence. And the problem for the courtroom, though, and it's a serious problem, is that if a memory has been changed, the person is not aware that it's been changed, and therefore they will be able to testify as though it were the truth, because they won't behave in any way indicating lying, because that is the memory, what the memory has become. So in the legal context, it becomes problematic. So suggestibility is a problem, but it's not just a problem for children, it's a problem for every witness. And what does the research say? And I think it's important for us to have, just very briefly, I've taken a few of the information from different tests, just to give us an idea of what we are looking at. So for example, one of the earliest, most well-known German psychologists, Stern, he focused a lot on suggestibility, and he did quite a number of experiments in which he would show subjects a picture, ask them to look at it for a while, and then afterwards he would interview them and ask them to tell him what they'd seen and ask questions about the pictures. And he would include not only truthful questions, but some misleading ones about things that had not actually been in the picture, or he would change some element of the picture. And in one study, he tested children between the ages of 7 and 18, and he found that, and this is really important for our forensic context, he found that free recall produced fewer mistakes than when we actually asked misleading questions. And the younger children were more suggestible, although even the 18-year-olds were suggestible. So it's not just the young children, but what comes out of his research that is important is it's the way we ask questions that's really problematic. Where somebody is given an opportunity to tell their story freely, you tend to find less mistakes. So three important things that came from his findings, and I highlight them because they're really relevant to our courtroom scenarios and to our cross-examination, our statement taking, and all of those things that we do. Subjects should not be questioned repeatedly about an event. The repeated questioning created problems. And the original verbal answers, when they first tell their story, is much better. Their first time they tell the story is much better remembered than the actual event. So this has implications for the courtroom. If we interview a child on numerous occasions, there is a greater likelihood for information to be incorporated. And what he also found was that the questioner the person doing the questioning was in many cases responsible for the unreliable evidence because of the way in which the questions were asked. Now, those kinds of elements are really important, and they've led many academics to argue that we should not be using an accusatorial system for child witnesses, but rather more of an inquisitorial system because of the way questions are asked and can lead to inaccuracies. Lippmann also did some research on suggestibility, and he said that children were less reliable than adults because they paid attention to different things compared to adults. Session, this links very much again to our cognitive development with young children who will centrate on one particular element to the exclusion of others. So their memory will therefore just be focused on what they have taken in. It does also mean that children very often don't have information about peripheral detail, which unfortunately is what a lot of cross-examination focuses on. So it is this factor that children don't really concentrate so much on the things we're looking for that makes them more suggestible, because then they're easily able to be influenced because the memory is not very strong. Also, what he highlighted, and again, this is very important for our legal context, is that children are questioned by adults, and not just adults, but important adults in the community, police, prosecutors, judges. So these people have a lot of authority about it, and the child is questioned about events that are not necessarily important to the child. You know, whether the color of the blanket on the bed was blue or purple or red is irrelevant to a child. In a courtroom, this becomes a vital piece of information. And as far as the child is concerned, if you keep asking me a question and it's obvious you want me to say it's blue, then I'll say it's blue because I don't understand the ramifications, and I will comply because as an authority figure, you know more than I do. Then in the 90s, we had a whole revival in this whole issue of child witnesses, lots of research being done by developmental researchers on whether children are reliable or not. And what the research actually found was that children are not as suggestible as we would like to believe, or as we have believed, especially in the courtroom. There've been a number of mixed findings. In some studies, children have been more suggestible, but in other studies, children have been less suggestible than adults. So there've been mixed findings across all the studies that they've done. But in general, what the studies have found was that young children are no more suggestible than adults are. And in fact, there are numerous studies which have shown that children as young as 5 are quite able to answer objective questions without being suggested to in the same way as adults are. Just to introduce you to a few of the studies, the more ones that have got a lot more attention. For example, Duncan, he worked with 6-year-olds all the way up to college students, and did the same kinds of experiments. They show slides or they show videos, and then they interview about the contents. And his studies showed that children and adults were influenced equally by the questions that were asked. And then a second analysis, when they looked at those instances in which there was a correct memory, they showed that the younger children were less influenced actually than the older subjects. So other experiments in the Marin one, they found that children were as capable as adults as in answering direct questions about an incident, and that they were not any more easily swayed into incorrect answers than adults using leading questions. But some studies have found that under certain circumstances, children may be more suggestible than adults. And in the Cohen and Darnick studies, they looked at children all the way from 3rd grade, 6th grade, and college. And what they found was that the 3rd graders had poorer memories, the younger participants had a greater tendency to accept the false suggestions. And they related this to the fact that the memories were weak. But all three groups were influenced. The younger ones a little bit more because their memories were weaker, but there were none that were not suggestible. And again, as I say, that the analysis showed that the younger children had difficulty encoding some of the events in the video, which then obviously resulted in weaker memories. So various studies, but generally the studies seem to show that we're all suggestible. Younger children may be more suggestible, slightly more suggestible, simply because their memories are not as well developed as those of adults. And the Goodman study, which is a really good study, they found that adults were better than 6-year-olds and 6-year-olds were better than 3-year-olds. But when they were asked accurate but leading questions, the 6-year-olds answered with the greatest accuracy, followed by the 3-year-olds. Sorry, this should be 3-year-olds, followed by the 3-year-olds, and then the adults. Your adults tended to make much more intrusion errors, so they would let inaccurate information intrude on the memory, which they didn't find as much in the younger children. So although, and this is quite important in terms of the abuse scenario that we're talking about, although the younger children were found to be more suggestible than the adults, this did not relate to the central information that was encoded, but rather to more of the peripheral information. One of the studies that has received the most attention is a study by Saywitz, because one of the problems, obviously, of doing research in the field of child abuse is that we know that child abuse is a trauma and will create heightened arousal in terms of memory or dissociation in terms of memory. So it's going to have a different impact. But it's impossible really to do research on children's memory while they're being abused and after. So Saywitz was one of the researchers who kind of got the closest when she did a study on groups of children who were having medical exams by a pediatrician at the school, and half 5 and 7-year-olds, and half of the girls had their spines examined and the other half had a genital examination, and they were then interviewed afterwards about the examinations. And again, her findings were similar, that the older girls were more accurate than the younger girls in terms of the misleading non-abuse questions. There was no age difference for misleading abuse questions. And I think that's really important, because that's what the research has been finding overall, is that it's very difficult to get the children to be suggestible about the core element of what has happened to them. It's much easier to get them to be suggestible about peripheral detail happening around, leading up to, afterwards, etc. But the actual crucial act of the abuse part, it's really difficult to get them to mislead them in terms of that. And in fact, the 7-year-olds made no false reports of abuse. The 5-year-olds were misled into making false statements in only 3 out of 215 opportunities, even though they were asked leading questions. So the findings show that it's not easy to mislead children into making the actual allegations of abuse. It's easy to confuse them about peripheral detail, but not so much about the core elements. And what was interesting is when I say they made 3 false statements out of 215 opportunities, those 3 false statements actually related to leaving out information and not making up. They just excluded it because they didn't know. Very important as well is that most of the children who had the genital examination did not disclose the genital contact unless they were specifically asked about it. So that's another important factor to keep in the back of our heads when we're thinking about children in court. So in summary, adults recall more about an incident than children do, but there is no research support for the idea that children are always more suggestible than adults. And as I say, there are discrepant findings. In some studies, children are as good, sometimes not as good. And they attribute this to the fact that it's not just about age. In all of the studies that we look at how good are 3-year-olds, how good are 5-year-olds, how good are 7-year-olds, but there are other factors that are interplaying at the same time, not just the age, but attention span, whether the child is focused on what has been happening, all other factors that could be linked to it. So it's much wider than simply an age issue. But it's very clear that if an event is understandable and interesting to both children and adults, and if their memory of it is still equally strong, you may not find any difference in suggestibility in terms of age. If the event is not encoded well, whether it's an adult or a child, you will find that there will definitely be a difference then. And your younger children will have greater difficulty than your adults. So it really relates to the centrality of what the child is talking about. So in all the studies that have been conducted, they have failed to find any simple relationship between suggestibility and age. And instead, what they have found is that there are other factors that do interfere with suggestibility, and they apply to both adults and children. Now, this is a dilemma for the legal system because our trials are conducted on the belief that examination and cross-examination is the tool by which we are able to find the truth, and credibility is judged by the way the witness performs and the amount of detail their evidence is, and that they don't contradict themselves, and that cross-examination is going to reveal any form of lying. But a suggested memory is going to replace the original memory. So your witness will truthfully, in inverted commas, be relating what they remember and will obviously appear credible. So although they're not lying, they're still nevertheless not telling the truth. But again, as I say, this relates to both children and to adults. Now, what could the possible reasons for suggestibility be? The first one would be the relationship between the children and the adults, which is what I have mentioned already in terms of authoritarian. Children believe that adults know everything, that adults are correct. So if that's the response you're seeking, then I will comply. Obviously, the level of development in memory retrieval is going to be important. And then the way memories are stored by humans. And this is quite an interesting part as well. Now, researchers have conducted lots of experiments with adults as well, where they have asked repeated suggestive questions, trying to convince an adult that they have experienced an event, sometimes even a traumatic event during their childhood, which they in fact had not. So the creation of false memories. And they would implant this memory in the subject's memories, and the adults came to believe that these memories had actually taken place. So although the memories were implanted, it was difficult to convince the subjects that those memories were inaccurate. But now, when we hear about that, we have to see it in terms of the context, because implanting a false memory requires quite a considerable amount of brainwashing. And especially for very young children who don't have cognitive capacity to create the relevant images to go with this memory. So this is not something that could be done very easily by a layperson. What would happen is that on closer scrutiny and on questioning, it would be very easy to discover the fact that this memory was not complete. But this experiment, as I said, was done with adults. So what would the reasons be? As I said, the relationship between children and adults. We know that this relationship is not an equal one. It's one of dependence, respect for the person in authority. And as I mentioned, this is even worse when we are talking about important people like teachers or lawyers or prosecutors or police. And that relationship is obviously going to affect how the child interacts, especially where it's somebody that the child trusts. So if it's a police person, or if it's a judge, or if it's a prosecutor, because the child will assume that that person would be assisting them, would not be lying, would not give them false information. So they would be very willing to accept whatever those people say. Now, if adults provide hints to answers, the child is going to assume that this is correct and try to please by responding to those suggested indicators. So this is what we use at school. It's what we use in terms of education with young children. When your teacher asks a question, she will give a hint and the child will respond. So when we do this in a courtroom, the child will respond in the same way, because a young child cognitively cannot work out that perhaps they're being manipulated in cross-examination, or they will just simply assume that this is an adult who they can trust and who is helping them with the answer. The other issue is retrieval skills. Now, this is one area where children have greater difficulty than their adult counterparts, because we all have the capacity, and children as young as 6 weeks have capacity for recognition memory, same as adults. But it's the ability to actually retrieve that story out of one's head that is difficult for children and somewhat easier for adults, which means that if your child has got a poor recollection of an event, it's obviously going to be easy to suggest something to them. But again, this is the same with an adult. If you have an adult whose memory is very weak about something, it's very easy to suggest information to them. It happens to all of us all the time. If we're saying, did you see so-and-so last year? And you kind of have a vague recollection that you saw them maybe, and then the person will say, yes, man, they were wearing that blue dress. And you don't really remember the blue dress, but yeah, next time you remember that, the person will have a blue dress. So when the memory is weak, we will accept the suggestion. Again, remembering all the time, we're talking peripheral detail. So with your younger children, their difficulty is retrieval. And this is what makes it difficult for them to access that memory so clearly and then not be influenced by us. And of course, retrieval is exacerbated by stress. And now we're talking courtroom where I'm very stressed. So my retrieval of my memories is going to be quite complex on its own. Plus then I have cross-examination where I'm being asked leading questions. So then I'm really easily able to be suggested too. Always remembering, of course, that this is an unconscious process. Now, important point to remember as well is that memories are not stored like little movies in our heads. We create memory from images and pieces of information that we've stored from somewhere else. So, for example, if you were asked to think, if I had to say to you, think of a red car, okay, you would create an image in your head about the car. That car would have a particular shape, a particular model, particular wheels, particular doors. I didn't give you that information. I simply said a red car. But your brain has information of other cars and other red cars, and you create that image in your head. So memory creates images in a similar way. So when an event is suggested, you create an image in the head. When you tell me a story, I create an image in my head of that story. So, and this is how suggestibility works in your witness or in anybody, actually. And of course, the more plausible the event, the easier it will be to accept. Now, what are the factors that affect suggestibility? And I'm going to go through these quite quickly so that we don't be too late. Obviously, the degree of suggestion. The stronger the suggestion, the more likely it is going to be successful. Did Uncle Henry touch your penis, which is mild suggestion, as opposed to, I believe Uncle Henry touched your penis. Isn't that right? Those are strong suggestive. And you can see it goes back again to us evaluating court processes, because we have this strange rule that says we are not allowed to ask leading questions in examination in chief, but we are allowed to ask leading questions in cross-examination. That makes no sense, because it means I can then be suggested to in cross-examination. The centrality of the information to be remembered is another issue. And as I say, the research that is available has shown that it's really difficult to change the central core. It's very difficult to get children to believe that they've been abused when they haven't, or to change the elements of the central core of abuse, where that has been a focus. Whereas it's much easier to confuse them about whether there was a noise next door, who was present else, anything else that's peripheral. And of course, it's going to also depend on what the child focuses on. And with children, they will scan events starting with the point of greatest action, which often means that they miss the peripheral surrounding detail. And in some research conducted on cross-examination, they have identified that sometimes up to 98% of questions in cross-examination relate to peripheral detail, because that's where it's easy to confuse the witness. Obviously, the strength of the memory, as I said, the weaker the memory, the easier it is going to be to suggest to somebody. And intimidation. Now, intimidation it doesn't have to be threatening intimidation. Intimidation is authority, where the child accepts that you are the authoritarian figure. But if we think again of cross-examination in our courtrooms, then it's very easy for children to accept that information as correct and make it part of their memory. Here comes the very crux of our suggestibility issues, and that is interview techniques. For suggestion to take place in an interview, the interviewer must convey the answer in some way that they want, and they provide cues. And we can look at the cues now. Cues can be very subtle, but they will make the witness change their belief about what happened. You know, if somebody says he was looking angry, are you sure he was looking angry? Could he not perhaps have been just afraid? Yes, maybe. And then you start to interfere with my memory. But please remember at the back of your heads while I'm saying all of this, the use of these techniques doesn't necessarily mean the witness has adopted them. Some witnesses are resistant to suggestion and to these types of suggestion. What I'm just doing is highlighting how suggestion can occur. Your questionable interview techniques is very important for us, because our children are questioned by police. They're questioned by social workers, they're questioned by prosecutors, they're questioned in court. And if we are not using proper techniques, then we are going to have the danger of contaminating evidence by suggestibility. Now, the first big issue is overzealousness on the part of the interviewer. This is where, and it can be very subtle. You can have it quite harsh, where we're talking about cross-examination, where we ask the same question and we push the child to say what we want. Or it can be very subtle, where I am, as I show you in the next slide, where I am biased, and I believe, as an interviewer, I believe that abuse has occurred. So I only ask questions leading to abuse and leading to the conclusion that abuse has taken place. And of course, then I provide a lot of encouragement. So when the child says something, I nod and I agree, and the child sees that this is the information you're looking for, so then they give you that information. So it's that kind of information. Also, tone. Children are very sensitive to tone. So if my tone indicates approval to what they're saying, if my body language indicates that's approval, I'm nodding, this is what I want you to say, our children, in the same way as they would with a teacher, would accommodate us. Another big problem for suggestibility is this whole issue of repeated questions or interviews. And these are highly problematic, because repeated interviewing is not necessarily a bad thing. You know, everybody says, oh, the child's been interviewed 3 times. It's not necessarily a bad time if she's been interviewed properly. It's where we start to add information in the interviews that we have a problem, where we start to incorporate misleading information. If children are interviewed in a forensically sound manner, then you will not be suggesting any information. Repeated questions are problems for children because they think they've given you the wrong response. So then they change their response and that starts to interfere with their memory. So repeated questions are never asked in an interview. The one that creates the biggest problems for our kids are leading questions, which, as I said, are allowed in cross-examination. These are questions that suggest the answer that I'm looking for. And our children are particularly vulnerable to these because this is how we teach them in an education environment. And we are authoritative individuals, we're important people, so they will think we're assisting them and they will agree with us. And then, of course, that information can become incorporated into their memory. So in summary, and I know this has been a kind of a speedy journey through about 100 years of research. The research agrees that if children are interviewed properly in a way that is supportive and also in a way that is clinically and forensically accurate, then their accounts will be highly reliable and you won't find suggestibility. But it goes back to what I started with in terms of, in order for this to happen, all your role players need to be trained. Your police need to be trained on how to conduct a forensic interview without contaminating. Your prosecutors. And we have to have systems in the court where children are not, in terms of cross-examination, intimidated or led into giving false evidence. Now, how does this suggestibility affect court preparation? I just want to clarify at the beginning the term court preparation, because in some instances, people talk about court preparation as the preparation of the child's evidence for court, where you go through the evidence with the child. The other one relates to preparing them for going to court, which as in court preparation programs. The first one, where you're preparing their evidence for court, this is usually done by prosecutors before the witness goes to court. And what is important here is, this is where the term tutoring often comes in, of tutoring the witness. In order for this to be circumvented, we have to have protocols, forensic protocols in terms of how children should be interviewed, training on how to interview in a forensically sound way, and so that we don't create false memories. Because otherwise, if we do all of the things we've said, there is the possibility that we can contaminate the child's evidence. Court preparation. If we're looking at court preparation, now court preparation is a whole different bucket of stuff. Court preparation has created a lot of confusion for courts because they've confused it with the tutoring and preparing the child for their evidence, whereas court preparation programs are life skills programs, and they are used to empower children so that the children can testify more effectively by helping them to deal with their fears, by helping them to understand the process, and by helping them to understand what they're supposed to be doing there, what their role is, because that's what they need to know. Children have no legal degrees. They have no idea what they're supposed to be doing in court. In fact, when we've interviewed many kids, when they go for their consultation with the prosecutor, they'll tell us that that was their court experience. That they have no idea what going to court is all about. And that leads to a number of misconceptions. So, and I've highlighted some here that we have identified in research with kids. Kids believe that they are actually on trial, that you are testing them to see whether they're telling the truth or not, which in a sense is correct. But what they believe is that if they make a mistake, or if they do not, if they can't remember, or if they don't have the whole story, they'll go to prison. So that results in many children simply saying they don't know because they're too scared to answer in case they make a mistake and then they're going to go to prison. They confuse court with jail. They're also cognitively egocentric, which means they believe that everybody in the court already knows what happens because they've spoken to the police, they've consulted with the prosecutor. So they assume everybody in the court knows what has happened. So they leave out a lot of detail. They believe that if they're asked the same question twice, that the first time they gave the wrong answer, so they'll change the answer. They believe that they have to agree with adults, that they're not allowed to disagree with an adult. So they have all these beliefs of what is happening in the courtroom. And these misconceptions increase fear. Fear increases stress. Stress affects my memory. So this is the basis really of how court preparation programs were introduced, is that by providing the child with enough knowledge to be able to be a witness, we remove a lot of the misconceptions, we remove a lot of the fears, and we give enough information for the child to know what is expected of them. So that's really what your purpose is. Because if you look at children's fears, and these are also some of the fears from research we've done, as well as international research, children are afraid. They don't understand what's going to happen. They don't know what to do. What is going to happen in there? What do they have to do? They're scared of having to talk in front of adults. They're scared of seeing the accused. They're scared they won't be able to answer your questions. They're scared that they're going to be sent away from home, that their family will be angry with them, that they may not be believed. There are so many fears that are contained within that child when they have to go to court, which is very often the reason why our children do not talk. And this stress, as we know, I mean, stress is going to interfere in such a way that very often our children don't recall much, and they, in much the same way as we do in an exam when we panic. You know, we have blank spots where we can't remember, and this is what happens in the courtroom. So because of all of these and the stress, the idea is prepare the child for the process so that they're comfortable with the process. And what is court preparation about? It's about providing the child with basic information about the judicial process and the role players, about legal terminology, and a few stress reduction techniques. That's what court preparation is about. And just so that we have clarity, I'm going to look at the content of some court preparation programs to give you an idea of what content we're focusing on. As I said, the objectives are to demystify the courtroom. You want the child to know what their role is, what to expect, what's going to happen. And in that way, we reduce their fear and their stress and hopefully make a better witness. So in court preparation, you deal with who the people are in the courtroom, who the judge is, what the job of the judge is, what a prosecutor does, what the defense lawyer's job is, what a witness's job is, if there are intermediaries or court support people or court orderlies, just explaining. And of course, this gets done in developmentally appropriate ways depending on the child's age in a program. We look at what do courts look like. This can include taking the child to see the courtroom, to see where they will sit, so that the room is not unusual or scary for them on the first day. And where you have CCTV, we take the child to the CCTV room, we let them see how the equipment works so that they are relaxed with the equipment on the day. Brief introductions of what happens in the trial. And again, we're not doing a law degree, so here we give information in terms of what children require. You know, that the prosecutor is going to help you tell your story. So they'll ask questions just to make sure everybody understands. Then the defense is going to get a chance to ask you questions too. They may ask you the same questions, but that's to make sure that they understand what's happening, you know, what your role is, and the issues of the procedure. So when I know now that I'm going to be asked by two different people and the reason why, then it makes greater sense for me. And what is the role of a child witness? What's your job as a child? Your job is to listen carefully to the questions, to answer them, and to tell only the truth. And then you do little things like, and if you don't remember, that's fine. Then you say you don't remember. So giving them an understanding of what their capacities are. For older children, we will look at what is a verdict of guilty or not guilty and explain it to them. Younger children, very often it's not necessary because cognitively, your very young children are not going to understand what that means anyway. So having an understanding of what the sentencing process is, the competency examination that they're going to have to do, games relating to competency, so that when they get to court and have to do a competency test, they understand what the purpose is and they're able to do it. The kinds of questions and how to answer them. And again, what is really, really important about a court preparation program is that the details of the child's case are never, ever, ever, ever discussed. This is a life skills program. It could be offered at schools. You're teaching a child about a court process. It's not about their case. And so when we talk about the kinds of questions, we talk about, you may get asked questions that you can't remember. What are you going to do? You may get questions about that you don't understand. What do you do? So it's more empowerment as opposed to tutoring. What the child's role is, as I said to you, and they include de-stressing techniques. So if you're sitting in the box and you're getting really scared, what can you do? Okay, squeeze your hands very tight, let them go, breathe deeply, whatever exercise the program is going to include. So your court preparation program has and is often done by people who are not involved in the case. So the child's case is never discussed, it's never an issue, so there never becomes an opportunity for tutoring. And in fact, in the court preparation programs, you never ever deal with child abuse either. If we're talking about a crime, we usually talk about theft or a robbery or car accident or something like that, but never about abuse, to make sure that you do not have any kind of suggestibility happening. So, this is really important, is that court preparation is an educational program. It has nothing to do with the child's case, and the details of the child's case is never discussed. In fact, your court preparation staff are always told, if the child wants to say something, then you tell them that they need to go and say it to whoever else is working with their case. But children don't talk about their cases. We ran preparation programs for many, many years, and we've never yet once had a child who's ever referred to their own case. All have pretended that this was a life skills program and none of them had a case. So I think it's really important to be aware of the fact that the two are very distinct. The one relates to suggestibility and infiltrating information, whereas your court preparation is just a life skills program and has nothing to do with the two. And I hope in that hurry, I've managed to clarify some things.
Karen, there are some questions that have come from the viewers, and your sharing of some of the experiences have also raised critical issues. Let me start with the whole court preparation issue. Now, some of the challenges of the court preparation program, I mean, let me specifically talk about public prosecutors in India. They often discuss the issues related to powerful perpetrators and their ability to intimidate child witnesses and their families. In fact, in some cases, it has been observed that child witnesses are even made to travel with the accused to the court. Now, can court preparation programs actually mitigate trauma in the context of such difficult realities, you know, since you alluded to court preparation? Any thoughts on that, Karen?
It depends on the kind of court preparation that is received. Obviously, if you're talking about a once-off kind of court preparation situation, I don't think it's going to have much of an effect in a scenario like that. In some of the court preparation programs, for instance, they run over, for instance, 3 months, 10, 12 sessions, where children meet once a week and play games and learn about court and are empowered. You're more likely for something like that to have an impact, as opposed to perhaps a one-off session, which I can't see having much impact on that situation. But it's a real problem everywhere in the world, that one.
So what are some of the important systemic changes that you and your team have observed in countries where the Child Witness Institute has supported the development of court preparation programs?
Court preparation programs have enabled many children who would not previously have been able to testify because of the removal of fear. We've done a number of research projects, for instance, us and at the Institute, with children as young as 3.5 who've had to testify and have been too terrified to testify, and cases have been withdrawn, and then they've put them on preparation programs, and these kids have gone back to court and they've testified. So the understanding, the removal of fear is very often enables the child then to understand what's happening and to talk. And it's not just so much also only the child, because remember, court preparation has got an element for parents as well. And that's an important element, because that's the part that supports the child as well. So when you have that unit that's supported, you will find that the child it's easier for the child to testify.
But given the issues with memory distortion and retrieval in the context of difficult and traumatic experiences, even in adult witnesses, could you share your thoughts on the requirement for a comprehensive witness preparation program and the function that they serve in terms of improving the adjudication of offenses?
Well, in terms of preparation, you don't want to interfere with the child's memory or story. So that's the difficulty, because you don't go there. The child's case is therefore never discussed. And so our issue relating to memory loss or has to be dealt with in other ways. And other countries have, for instance, what they've done is they have videotaped the child's first statement in order to, so we have that. So that, for instance, and I'm not sure what it's like in India, but in South Africa, for instance, our kids can testify up to 5 years after an event. And then you have the original video of what the child said. But you have to mitigate it in other ways. We can't mitigate it in terms of court preparation, because, as I say, court preparation has got to stand away from the details of a particular case.
There are a couple of questions, Karen, that have come up from people who are looking and viewing this program. Some of them pertain to this whole court, preparation of the child. So, who actually prepares the child for the court? And if the child and the child's family are, let's say, not literate, as is often the case in a country like India, how does one navigate the complexities of reality of that nature?
When we developed our court programs, and I'll use ours as an example, but internationally it's the same. They're cognitively appropriate, obviously. So, for instance, you have a program for under 7s, which is based mostly on pictures, because under 7-year-olds can't read. So the content that is used can be appropriate to people who are literate or not literate, because a lot of it is talking. It's about sharing about what happens, showing pictures of what happens, and for kids playing games in terms of integrating the information. Who does court preparation? That varies from country to country. In South Africa, we have specific court preparation officers who are appointed at each court, and they are responsible for court preparation, distinct from the prosecutor and whoever else. In other countries, it's run by NGOs, it's run by social development. I've even seen it run in medical schools. So it doesn't really matter who runs it, as long as they have a standardized program and they've been trained in terms of running it. Of course, the best case scenario is that something like this needs to be included in a school curriculum, because then all kids have it.
One of the features, Karen, of the adversarial criminal justice system is the right of cross-examination. Now, typically, as in the Indian system, there are certain restrictions to guard against suggestibility during the chief examination, but these restrictions typically do not apply to cross-examination. Now, the result is that the defense counsel are permitted to ask leading questions, and actually till 2013 were even allowed to ask questions relating to the witness's character.
Yeah.
So do you believe that suggestibility is also a factor to consider in harsh cross-examinations and not just in the prosecution of the case?
Well, in fact, most of the suggestibility occurs in cross-examination. And with the specialization of judicial officers, we're beginning to see, very slowly, but we're beginning to see an acknowledgement that perhaps we need to move away from leading questions in cross-examination. So we've recently had a judgment where the judge stopped a defense attorney and said, "I'm sorry, but that's a leading question. You can't ask it." And of course, the defense said, "But I'm entitled to ask leading questions. This is cross-examination." And the judge said, "Yes, you are entitled to ask leading questions, but you are not entitled to confuse a witness. And therefore, the leading question is going to confuse the child witness, so you may not ask leading questions." So it's that kind of change we're going to have to see in terms of, if we can't do it in terms of legislation, we need to be able to see that in terms of research, what's happening is actually wrong. It's confusing children and it's creating incorrect evidence.
Thank you very much, Karen. There are many other issues that have come up from the viewers of this program, which, considering its very India-centric nature, I will put to Justice Madan Lokur in the final segment of today's session. The issues specifically are these. The Honorable Supreme Court of India recently issued directions with regard to the setting up of vulnerable witness courtrooms across the country. Now, apart from investing in child-inclusive courtroom infrastructure, the question is, what kind of recommendations are critical from a court preparation standpoint? And, and during all this, if the accused says that the child is tutored, as somebody has put on chat, then what will happen? So a lot of these kind of issues, and we have a system here also of what is known as a statement under Section 164. And in fact, one of the questions from Prasanjit Das from Assam is, what should one ask while recording 164 after the charge sheet is filed, and what kind of questions should be asked? So if you were to put all these together in terms of court preparation, in terms of the kind of directions that the Supreme Court has issued, I would now like to invite Honorable Justice Madan Lokur to give his concluding remarks and also specifically address the issues that I have raised. Justice Lokur?
Yeah, thank you, Shekhar. And thank you, Karen. I think that was a remarkable presentation. It just shows, Shekhar, if I may say so, that we have a lot of homework to do, to be able to understand how best to, assist children in giving their testimony without being influenced through external or internal factors. You see, the idea of questioning, which Karen had referred to, is I find it very interesting in the sense of what kind of questions to ask, what kind of questions not to ask, how to ask the questions, how not to ask questions. It could apply to anybody. It could apply to the court. It could apply to the police, the prosecution, whoever it is, the defense counsel, and misleading questions. Now, I remember having heard of an incident many years ago when I was still studying law of a judge who had asked persons who smoked cigarettes whether the camel cigarettes, whether the man was standing by the side of the camel or whether the man was sitting on the camel. And when people gave their answers, the fact of the matter is that there is no camel, there is no man in the camel cigarettes packet, but well, smokers didn't realize it. So, these are areas I think which we need to look at, we need to understand, suggestibility, as I have been able to understand from Karen's presentation, is falls short of tutoring. I mean, tutoring is of course not permissible, but suggestibility, well, it can happen in different ways. So really, I think we need to, have a far greater understanding of how to deal with child witnesses. What are their fears? We need to also educate ourselves. When we talk about misconceptions, Karen had mentioned about misconceptions of children. Well, I think we as adults also have certain misconceptions about children, right? So I think we need to look at that also. Training, of course, is absolutely necessary, and it can't be done over, maybe a couple of lectures once in a while, but it requires far greater, or far more intense understanding and study of what are the problems that are faced by children and by adults while trying to find the truth in a case. Coming to your question, Shekhar, about infrastructure, I have no doubt. I have no doubt in my mind that the infrastructure that we have in the courts is really not conducive to, have a friendly sort of an atmosphere. And I'm not talking only about children. I'm talking about adults as well. So very often, when a person goes to court for the first time, whether he's a witness or whether he's, just a litigant, not necessarily a witness, gets intimidated by what is happening in the court. Sometimes because of the aura of the court, sometimes because of, the hustle and the bustle that's going on in the court. I can imagine, what children would be going through. I would like to say that, yes, of course, some progress has been made, which I did say in the opening remarks, where we're trying to segregate children from the person who's been accused of sexual abuse. But these are, ad hoc arrangements. I think we need to look at it a lot more scientifically. That are we, doing the right thing by putting a child in a room with a CCTV camera over there? Sometimes the presence of a CCTV camera itself can be intimidating. Oh, you see, I'm being watched. So I think we need to study these issues very carefully and then arrive at some conclusion. It's all right, that the Supreme Court has said that, we need to improve the infrastructure. Yes, we do need to improve the infrastructure. There is no doubt about it. But how do we go about it is what is important. And for that, we need to not only get the judiciary involved, we need to get, child rights activists involved, but we also need to get the governments involved, because that's where the money is going to come from. That's where the funding is going to come from. It's a pretty long haul. It is not something that is going to happen overnight.
Indeed, sir. All of us at SAMVAD have a lot of work to do, and all of us who are interested in the welfare of children as a whole collectively have a lot of work to do. And thank you very much for bringing to our notice that the whole issue of memory and memory retrieval in the context of traumatic experiences, particularly where, a comprehensive witness preparation issue, the architecture, the ecology, the segregation notwithstanding, have we still reached a stage where we truly do justice to children who have been hurt and abused, is a question that we all need to ask ourselves. And this indeed is the framework and spirit in which this entire 4-part series has been organized in collaboration with the Child Witness Institute. There are still some questions that we will be addressing in the sessions as we go by. We have in the past also put out some of the ways of questioning and the ways in which the court system should actually function, its ecology and the structure and the ways in which a child victim witness is actually treated within the dispensations of the court and all the processes therein. Thank you very much, sir, for your presence throughout this session and for the wisdom and the experience that you have shared both at the beginning and towards the end of the session, which we will take on board as we continue with our work as part of 10 years of this law, POCSO 20. This year is the 10th year, and it's indeed a year of reflection of where we have progressed as far as this law is concerned in providing justice to children who have been hurt and abused. With that, Saurav, I hand over the session to you to close the session and also let us know what we have in store on the session on 22nd. Saurav?
Thank you very much, Dr. Seshadri. And of course, a sincere gratitude on behalf of SAMVAD to our guest speaker for the day, Dr. Karen Mueller, and of course, our Honorable Chair, Honorable Justice Madan Lokul. I think the session is, of course, as Dr. Seshadri mentioned, raised perhaps more questions than answers. I think that's important to move the conversation forward. Again, thank you to all the participants who've joined us for part 2 of this series on child forensics and child sexual abuse cases. As Dr. Seshadri mentioned, we are not done yet. So we will be returning on 22nd of this month, that is next Tuesday, with part 3 of the series, Forensic Issues in Eliciting Evidence from Young Children or Preschool Children, which is also an increasingly important area of child forensics. Session at the same time. So please log in from 6:30 p.m. to 8 p.m. Through this part of the series, that is our next session, we will be discussing what are some of the cognitive language limitations in young children, what are the possibilities for misunderstanding in young children, and most importantly, how do we then elicit evidence from young children in a way that is forensically accurate. So we hope to see all of you next Tuesday on 22nd March for part 3 of the series. Thank you once again, everyone, and good evening.
Good evening.